Hi, a very good evening, everyone. Very warm welcome. I'm Tarun Khurana. I'm from Khurana Khurana IP attorneys, and waiting for a few more colleagues to join in. But I think it's time, and we'll start, and they'll keep coming in. This is in a series of a number of other webinars that we have done in the last about 4 or 5 months, and as we are sort of unlocking, the density has become a little sparse, but we are trying our best to match up to the pace and continue the momentum. Thank you very, very much for again taking out time and continuing to join us. I am uh, very obliged today to have a very dear friend whom I know for the last many, many, many years. I think about 8 or 9 years that I know Miku from, and then he was in Japan for many years as a representative of a very large firm in the US, and then came back and is now a partner with Procopio IP, which is a very solid firm based out of the Silicon Valley and many other offices that they have all around the US. And I leave a quick introduction for Miku to make for himself, but a very dear friend whom we work very closely with, and very pleased. I told him to keep it very informal, particularly because it's about 5 o'clock in the morning for him, and he had to get up at 4:30. So obviously, didn't want him to take the trouble for changing up. But thank you, Miku, for all your time, for taking this up very early in the morning for you, and look forward to hearing from you. The mandate of the session today is on artificial intelligence and patenting in that particular space. So we are talking about challenges that are there in prosecution as well as drafting of patent applications in the US in particular. I'll be happy to throw in perspective from the Indian practice if and when required, but otherwise the key intent would be to listen to Miku and see because he's been practicing in that area for a pretty long time. So Miku, over to you for a quick introduction, and then we can start off with the presentation that you have.
Thank you, Tarun. I hope you're able to hear okay. If you have any trouble, please let me know. And happy Friday evening to you and your colleagues in India. And thank you very much for your warm welcome. And it's been really great. I think we first met in 2006 or 2007, in fact, in IIPRD itself. And it's been really great to be a long friend and work together on many projects. And also, I wish you and your family are doing well, and everybody on the program is doing well today. And welcome from California, from Silicon Valley. My name is Miku Mehta, and I'm a patent attorney and partner in Procopio firm. I've been practicing for about 20 years. Before that, I was a software engineer for about 7 or 8 years. And when I studied in a university, I studied systems engineering, which had a component on intelligent decision systems. And one of the components we had was AI. At the time, we didn't have processing power, and we did a lot with hand-calculated nodes and extrapolation tables. So this was all theoretical in the AI winter back then, but now many of these things are coming to life, and they're becoming important from the patent world for reasons that we will talk about. I have spent the last 10 years in Silicon Valley doing a lot of drafting for companies small and large. And as Tarun mentioned, I worked in Japan for almost 7.5 years, and we continue to have a very strong relation and do a lot of work to support Japanese companies for their patent requirements in the United States. And so we also have some aspects from AI that we're familiar with for Japan and other Asia Pacific. And of course, we've discussed many years on the growth and activities in the South Asia area and India. So today, I would like to talk a little bit about some of the best practices and some of the things that we are doing in US drafting and prosecution in the AI space. So as you can see, we have today's agenda, which is to cover the 4 main points, which are what are the changes that have happened with respect to AI for prosecution and patent preparation. We'll go through some examples. Tarun has picked some patents for me, and he wanted me to go through and explain what happened in those cases and how we got the claims we did and what are some of the pros and cons. Talk about some of the practices and some do's and don'ts as far as how to proceed with AI-oriented subject matter when getting patents. So that's going to be our overall agenda, and we'll have some time for discussion. Hopefully, we will have a good discussion as we go through. And if something comes up, Tarun will moderate. So please feel free to send him a note if you have questions or however you typically do. So first, let's start by talking about what has caused the changes in patent drafting practice for AI-related content. Firstly, the concept of artificial intelligence generally is decades and decades old. It's probably at least 50 years old. The concept of a neural network, the concept of learning nodes and things like that. Predictive tools, all of that is rooted in probability and computational science. But what's really brought it to life is the growth of four related technologies, four supporting technologies that without at least most of these technologies, it wouldn't really be as effective in the world today. The first has been probably we call it cloud computing, which is a storage, and then access to big data. Big data gives us the ability to access lots and lots of training data and find ways to label it and use it as the inputs for AI. Before the advent of cloud and the internet-based access for the big data, it was difficult to assemble in a reasonable amount of time and with a reasonable level of consistency of the data. So I think big data and cloud storage has opened up the world of AI. The use of some of the algorithms and software, development of new ways of labeling, development of new ways of establishing inputs, fully connected layers and the like, and some of the supporting software, distributed systems that run software in different places or in parallel or batch up certain processes. With regard to the hardware, the growth of processing, the GPU and speed of processors. Now we have neural processing units, NPUs. And finally, the ability to be easily connected in terms of devices, device-to-device. 5G is on our doorstep now. We have very good telecommunication systems with LTE and 4G. When you aggregate these four different areas to adopt the principles of AI and run the training and execution phases, it's really those things that have made AI such a strong tool to help us do things in the real world. So the tool of AI has actually created some unique legal issues for they're patent related. So data rights, it's actually probably a copyright or privacy issue that when you use training data, maybe you're using images now for training sometimes, the rights to that data may be controlled by copyright or some other proprietary tool. What is our right to use that? What do we need to do when we talk about training data to avoid infringement of the use of the data? Patentable subject matter. If the concept of doing neural networks and artificial intelligence itself is well known, and are we simply taking what was done by pen and paper and making it faster by doing it on a machine? Well, some parts of the USPTO and some courts feel like you need what we call significantly more after Alice case. And this does actually come up a lot in 101. Multi-jurisdiction infringement. When you have AI, sometimes you have training in one jurisdiction and execution in another jurisdiction. How do you pursue patent enforcement? Similarly, the divided infringement within country. You have some part of the process done by clients that are pulling in data, and you have other parts centrally done on the server side or in a distributed manner. How do you go after a single infringer? Detectability. When you talk about using a neural network, where is the neural network and how do you detect it and prove that it exists and is being practiced by the accused party for the purpose of proving infringement? What are the damages? How do you calculate the damages on infringement of an AI patent? And then inventorship. When we talk about invention, is it the inventor of the neural network themselves? Is it the inventor? Is it the company or person that found a practical application for that AI? Is it the programmer that put the pencil to paper, so to speak, and converted the algorithms into something that was useful? Or was it the training algorithm that made the quality of the AI strong and the developers of the training algorithm or hardware? So we have multiple potential issues for inventorship. So with all the new technology and all of these legal issues, the USPTO actually, around this time last year, put out a request for comment for the public, and they have asked many comments. These are just some of the comments that the USPTO has asked, because the USPTO is also trying to develop a policy to handle AI. So I've just listed them. So what are the elements of an AI invention? What are the different ways that a natural person can contribute to conception of what is called an AI invention? Maybe some of you have heard of DABUS, D-A-B-U-S. You can look it up by searching later on the internet. But this is an AI inventor. So who is the inventor? Well, EPO and USPTO at least have held that you can't have an AI tool be an inventor. And I would say that an AI tool couldn't possess the intent to invent. So who would be the inventor? Could there be an inventor? May it be an invention without a patent? The PTO is also, of course, concerned about the US 101 issues, Alice related. Enablement and disclosure. How much do we have to disclose? Can we just say that a neural network is used and have it be well known? Or do we have to talk about that it's a CNN or DNN? What do we have to tell the patent office about the neural network? And then level of skill in the art. What is the ordinary level of skill in the art? What is the appropriate level of prior art to apply? What will be considered obvious? As I mentioned, neural networks themselves have been known for almost half a century, maybe more. So what's so special about neural networks that make them deserving of a patent? And how do we interpret the prior art? So these are some of the issues that come up. As I mentioned, Tarun has picked 3 patents that we're going to go through in some detail. But first, I'd like to talk about a few techniques that we have for drafting, for claim drafting and specification drafting. And this first slide relates to the types of things that we want to be careful about when we draft. So there are some aspects. Well, first of all, you have to consider what is the target of your patent? Is it defensive? Is it to demonstrate industry leadership? is it offensive? Are you looking to track the activity of others and potentially capture others? Is it for investors? Is it to protect your customers? So, for example, maybe you're looking to protect the server side. So make sure your claims are directed to infringement on the server side. Perhaps you're considered to the process of generating a request on the client side, the terminal side. So getting the claims right is the first important thing. The Judge Rich always used to say that claim is the name of the game, and I still believe that is the most important thing of all. Second is specification drafting. Some of you may have seen statistics, and there may have been programs on the difference in allowability and the difference in 101 rejections in the different areas of the USPTO. The Technology Center determines, in some ways, well, it's not determinative in the strict sense, but the business process patents are all in Technology Center 3600, and the allowance rate is very low for business process patents. So if your AI patent goes in there, and there are automated tools the USPTO uses for processing, then it's going to be a lot more challenging, because the highlight will be not your technology, but the business process. So get into the right art unit. Use the right terminology in your specification. We can talk a little bit more about that in the discussion. Consider licensing streams and divided infringement issues. So make sure you have use cases that relate to potential license streams in your specification, and explain how the AI makes that special, if that AI does that. And then when you think about divided infringement, when you're getting a patent or you're making a product, think about how the patent avoids the divided infringement issues we mentioned. And think about when you're making technology, how you can have the flexibility to design around. When you draft the patent, draft it from the accused infringer's perspective, and put in alternatives that make it less easy or more difficult to completely design around the scope of the patent, either offensively or defensively. So what about prosecution then? On 101, I think it's important to put in why the AI tool steps are not routine, and make sure the AI tool is explained in terms of its integration and its limitation in the real world, so that we're not claiming AI generally, but we're claiming the actual implementation of it. That will be important for 101. Consider the enablement issues. Consider how one would make or use the AI model and various iterations. Don't lock yourself in to a current neural network or a current heuristic, but where possible, show as much flexibility and show how the model would work with different tools. And then with respect to 103, sometimes it's good to do a search and then file the IDS, and then also think about, from the viewpoint of a human engineer and from the viewpoint of an AI tool, what the level of skill in the art is. If you can imagine a human having a difficulty doing something, but it being easy from the perspective of AI, consider how that might be perceived from a prior art examination perspective. So these are some of the practices that I would say to be considered. So now I'm going to switch. I have 3 different case studies, and what we're going to do is I've pulled up the prosecution history and the patent for each of those. So my idea was to go through each of these studies in some detail, and Tarun has picked up 3 of my patents, so that you can see them. So let me first go to the 454 patent. Well, let me first show you the cover page of the patent itself, 454, just so you can see the cover page. You should be able to see it now. Don't worry, I'm going to make it larger, but this patent is for natural language understanding. You can see we have a large number of drawings, about 37 drawings that we've put in with various details, various implementations and use cases, various structures. And then the specification is relatively thick with lots of examples and explanation as to how things work. And we have 19 claims. Yes, some of the claims are long, so let me show you in the file history and tell the story a little bit about what made this an interesting application from a prosecution perspective. So I'm going to go chronologically, and I've rubber banded what might be the interesting or important parts of this so that you can see. Going from oldest to newest, this is the prosecution history. This is the public record in the USPTO, and everything I'm telling you today is from the public record from just a review perspective. So we might end up flipping through some of the pages, but I just wanted to give you a flavor of what's going on. First, I'll draw your attention to a figure that should be able to give us some help in terms of sharing information on this application. So here you have figure 1, which is just rubber banded here for you. And I made arrows pointing to some of the key features. Now, for natural language understanding, there's a microphone, and then there's an automatic speech recognizer. There are other inputs. And then there's a language model for that. And then there's a natural language understanding unit with an NLU model. And then further on down, there is an NLU trainer. So these are some of the key features in this one. And you can see there are agents and outputs and action implementers. But I've just highlighted the key issues. And then just there's an abstract here explaining that there's a dialogue system that has NLU in a client-server structure. And there's a couple of if-thens, and there's an interactive voice response system available. So that's just to give you an idea of the invention. And then these are the original claims as filed. You can see the original claim had a client and with a text input method and an NLU, and then a server with a second NLU. So this is a situation where the invention might be located, or the claim might show the invention as located. Some part of the process is done at a client and some is done at a server. And this happens in AI. The processing may not always happen in one place. So this is an example to think about. So then we have a long specification. We're not going to go through it due to the time limitation, but it's about 225 paragraphs. And we'll turn to the file history, and we'll have all the other forms here. So you'll first see the examiner. This is the office action. First thing I'll point out is the art unit is 2600. So we're in the right art unit. We're in a very technical art unit for data processing and things like that. So we're in the right place. We're not in 3600. If you look at the way the patent application was written and some of the terminology, you'll notice that we focused on the technology rather than using more business-like or implementation-like terms. We have those in there, but we also focus on the technology. Then you'll see a rejection by the examiner under 103, an obviousness rejection. You'll notice that there's no 101 rejection. There's a 112 about something, but we didn't get a 101 rejection in this case. And we can discuss about why that didn't happen if we want. And there's allowable subject matter. When we draft, our goal is probably to have allowable subject matter in some of the claims, but we don't know whether the independent claim will be allowable or not until after the examiner does the search. So that's the first point. The second point is now we've interviewed the case. Interviews are very effective, and you can see that there is some explanation. In a period of 30 minutes or so, a lot can be accomplished with a negotiation with a primary examiner and the attorney. And so we interviewed the case, and what happened after the interview is we filed a response that basically added some new information. The examiner wanted to put in a confidence score. So we explained that a confidence score is determined. Broadly, we explained that it's done, but we didn't say where it's done. And we made an adjustment to the server language. So an amendment was made, and then a final office action was issued with rejection. And you can see there is more explanation now by the examiner of the rejection and why it would have been obvious. And we still have the allowable subject matter. In fact, I think we have a little more in the way of allowable subject matter. So we didn't completely give in to the examiner, but we negotiated upward and we did add in some features. So then you have to be persistent in these matters. And so what we did is we filed a second amendment. So it turns out that the real novelty here was the training algorithm. And one of our tips I will mention later is you don't need to put the training and execution phase together always. But we have a training algorithm that is configured to conduct a method that utilizes machine learning. So now we have the heart of this invention into the claim. Of course, when you put in a training algorithm, it gives you the novelty, but then what about infringement? You have to be able to detect somebody using a training algorithm and having that training algorithm use machine learning. So, that's a question for infringement. And so we next go up to what happened in the next stage here. And we used, again, so I didn't highlight this, but AFCP 2.0 is a very effective tool that can be used to avoid an RCE, and that was successfully done here, and the application was allowed. So this is one example of how AI makes its way into and prosecutes its way through a patent in the USPTO. I'd like to turn to a second example. I'm going to minimize these two, and let's go to the 618 patent, which you can just see the face page here. This is for using AI for generated glyphs. Again, we have a lot of drawings showing the algorithm, some information about the neural network and some of the outputs. And then we have a specification. This one is a little bit shorter, but we still have, in this case, 21 claims. So let's look at the prosecution on this one and talk a little bit about what happened here. So now we're going to go to the prosecution history of 618. So here we go. So you should be able to see this. So I'm going to go back to the end of this one, and we'll go through and you can see some of the drawings. I just wanted to highlight that you will see, again, I mentioned that we are putting in the details of the neural network and how the different layers work, and we're explaining what is the output. It tells us, well, is this a real image or a fake image? We look at the vectors, the generator, the discriminator. We put this level of detail in because maybe in this case there's something new, or maybe there's something we want to highlight. It's a judgment call how much you put in, but I think it's good to put something in and explain that this is just an example. It's not meant to be limiting. And then right here in the figure 4, we have steps of receiving an input, generating a vector, combining, using a first neural network to do a combination, using a second neural network to do a comparison, and then making a decision based on whether a glyph is distinguished from a potential glyph is distinguishable from an image, and if it's not, then it matches, and you can say that it's real, and you submit it. If it is, then you iterate. So, and then there's a chart showing where is the deep learning going on. So this is just to give you an idea of how we sometimes write specifications, particularly the drawings. And here's the first claim. And it's a method of creating a visual representation of data. We've got a nice broad independent claim 1. And because without the neural network, this might just be a more basic aggregation of 3 steps, we do indicate that the generating is done by a neural network. Will it be enough? Well, we don't know yet, but we have a specification that is directed to solving this problem. Let's see what the patent office said about this. So you'll see we have this long office action. Again, we're in unit 2600. Why are we there? Because of how we wrote the application. We focused on the processing and the technology rather than on simply the user interface or generating some practical output. We actually focus on the technology. And again, we don't have a 101, no 101 here. And then there is some prior art. It's actually non-patent literature. In this area, we get a lot of non-patent literature. We have a very detailed rejection under 102 of the independent claim. And then there will be some allowable subject matter indicated actually in some of the, I didn't rubber band it, but we did get allowable subject matter. Our goal is to get an allowable dependent claim and make sure we've right-sized our independent claim so that we have some room to amend if necessary, but we're not too narrow to start out with. So what happened after this? Well, guess what? We talked to the patent office. We did an interview, and the interview doesn't go into the details, but it's, again, a negotiation with the patent office to explain the invention and convey possible amendments. So after this, we must have filed an amendment, right? Let's see what the amendment looks like. Well, we were very broad to begin with. So after discussion and looking at the prior art, the amendment explains how the glyph is generated, detecting some variations and generating the glyphs based on input and the detected variations. Remember, we were looking for variations with the neural networks. And then we say where in the linking aspect further comprises associating the glyphs with the variation. And note, we're not talking about multiple neural networks. We're not saying where this is done. We're staying agnostic with respect to that. And even though we're incorporating some allowable subject matter, we still felt that we didn't need to put in this chart. Chart might be too narrowing because somebody could design around creating a chart. They could use a linked list. They could do a lot of other things with that show the glyphs. So we tried to stay as broad as we could and get in the subject matter as allowable. So what happens next here? Allowable subject matter on the patent. We had an allowance. So that was a good result. One action and in and done with an allowance. And again, we don't have in the claims too much. We'll go back to the claim, which will represent the claim as allowed. You're receiving the input, but it's not saying exactly where and what device this is done on. So we actually have good flexibility here in terms of hardware and who is the infringer. Now we do have to detect some things, but that's a whole nother story. And we don't have the time to pick apart too much on the claims, but I just wanted to show you the second example as a different way. The first example was, we had to work a little harder and put the training algorithm, because that was a very important part of that one. With this one, it's related to how the visualization is generated and how we put the neural network in the claim without talking too much. You'll notice there's hardly anything on AI here, but this is enough. This is an AI claim that captures the neural network, right? So this was the second example. So I like to now go to number 3. And for the third one, this will be 751, I believe. Let's see if that's the one. Yes. So 751 is about generating captions to summarize media files. And so again, we have the drawings which show in some level of detail what's going on in the AI. You have the RNN layers and the CNN and the inputs and outputs. And then you have thick specification and 22 claims. So we like to use as much of the claim, as many of the claims as we can. So let's do this one. I think we're doing okay on time here. So let's go through the file history and look at what happened here. So again, I wanted to show you, we go into quite a bit of detail as an example of how the neural network works and what's going on in different phases. And we do discuss this in the disclosure in more detail. And just look here at the different, these are just different ways. And when things are done in different ways using different algorithms, we show them with different charts. So we're not tied down to a specific approach. And if some features are optional, we show them in broken lines. Like here, we're using a neural network to calculate an importance score. We may determine whether it's representative of media content or not. And we may resegment or we may not. We may receive, this is for training, we receive the training file, and then we optimize the network. So we have that. We have a segmented training file, and then we partition into semantics and we optimize. So we kept this modular so we can stay broad. And then let's just look at claim 1 here. Again, similar structure. We have a neural network doing some calculating. There's some selection and some generating and output. And we have a fairly thick specification. Of course, it's focused on the invention. So, we had a broad claim here. So let's take a look at what happened. Okay, so again, we're in 2600, not in 3600. There's some drafting tips that would go there. We could do a whole workshop on how to draft AI patent claims in the language to use and not use, but hopefully this gives you a flavor. But here we have a 102 rejection. So the examiner thinks that they have found something that's very close. So we have a relatively detailed one. And this time, we did not get any allowable subject matter. So let's see what we did. Okay, well, we still go and talk to the examiner. And we have a fairly detailed explanation. and the examiner clarified their view on encoding. And because we don't have allowable subject matter in the claims, and because the examiner did find new prior art, we have to iterate, we have to amend. So now we have added more information here on, we already have the neural network, but now we have to add a little bit more on what is done at the different phases. The triggering event, we're talking more about the media file and the importance scores, and temporal separation and the triggering event are the main points here. So we add that in, and let's see what that did. It brought us a final office action. And you know what? The examiner still is not convinced. The examiner is still saying what we have added, because the prior art does have AI in it, according to the examiner. So, but the examiner explains that Lou doesn't contain this media file and actually has now moved to a 103 with a secondary reference. So what do we have to do? We gotta go back and talk to the patent office. We talk to the patent office as much as we can, and propose some more amendments because this new reference must have been significant, and because it was provided at final, we knew that the claim amendment couldn't be done with AFCP or final, so we did have to file an RCE. It's rare, but we did. But what did we do? We added in information on dynamically selected targeting. And so, is everybody able to see this? Is it okay?
Not very clearly, Miku. Actually, if you could just maybe bigger, just
bigger.
Yeah, this is.
How about that?
Yeah, that's much better.
Okay. Okay. Sorry about that. So you can see that we've added dynamically selecting, and this is another feature that we had talked about in those drawings. So so then what happens next? We make a, and look, we're keeping our arguments short because we already interviewed the case. It's not necessary to create a great deal of estoppel on the record by making written arguments. It's better to have a 20 or 30-minute call with the examiner to try to overcome the issues. So we file the RCE, and then what happens after we file the RCE? Well, okay, some examiners will be able to find new art, and so what's happened here is now there's a third prior art reference. So they've given us a three-way combination. And the point is that we are iteratively, sometimes it's iterative, sometimes we can do it in a single pass, but the examiner will come up sometimes with new prior art in response to an amendment, and that's just this examiner style. So we need another round. So what do? Went back for a third interview. And why do we do this? Because we don't want to put a lot of writing and on the record. We don't want to go in a lot of wrong directions with unnecessary narrowing amendments. We want to negotiate. We don't want to just shoot amendments and see what works and what doesn't work in the public record. It's better to have some kind of a discussion with the examiner. So now we've done that, and we talked to the examiner again, and the examiner needed more, even more. So we're getting a little narrow here, but the examiner says, well, you have to put in the media file, because the application has to say where the triggering event is going on. So they wanted a media file and a media segment, and there were some other amendments we had to do, but basically after the RCE, we're at the close to the end stage here, and then you'll see. I think the next one is the final allowance, or no, we have the allowable subject matter. So then be careful when you do get allowable subject matter. This examiner is very thorough and gave us a very detailed explanation. If you feel that this reason for allowance is not appropriate, it is possible to go back to the examiner and do some other activities, such as you can do comments on allowance, you can do a 312 amendment if it's not substantive, just to make sure what the examiner is saying is matching what your patent should be. So I know we're coming to the end here, but I have put these points, which we did discuss. These are the key highlights from these 3 examples. Make sure you have deep support with some broadening language, but also some deep language, different examples, different use cases. Think about continuations you may file to different use cases. So draft the original application with the continuation in mind. Avoid business process treatment by going directly into the technology and having your patent focus on the technology. You may want to have a list of terms to avoid, and then keep your eyes on the case law. These rules and the law are changing, so we try to avoid unnecessarily citing to laws, USPTO guidelines, and that kind of thing in prosecution, and focus agnostically, generically on claim structures and following the principles. Just some do's and don'ts. Let's start with the don'ts, get those out of the way. Avoid undetectability in your claims. Don't put AI features that are too difficult to detect. Don't narrow the claims to a specific NN implementation. Don't require specific hardware or telecom unless that's the key part of the invention. Avoid dividing between the terminal and the server. Avoid mixing of the training phase and the prediction phase or the execution phase in the same claim. And avoid claiming use of existing AI simply directed to a different type of data. That's going to give you a 101, or that's going to give you, an obviousness or 103 rejection. So what do we do? Make sure the claim has just the key broad novelty of the AI, if the AI is a part of the invention. Have claims directed to the training phase. Have other claims directed to the execution phase. Sometimes collecting the data is something special. Input data can be very dirty, and cleaning it up or labeling it or collecting it in a less inefficient way is important. Mapping could be important. And then think practically about the output and uses, not just for 101, but for your license streams, and maybe in continuations you might have other things. So these are the basic things that I wanted to get. It's a little packed, and I'm sorry for running a little over on your Friday night, but I hope that this basic crash course in some of the tips was helpful. Tarun, if you think this is a good time to open up to discussion and questions, I'm fully available, and I thank you for giving me your time today.
Absolutely. Miku, was a wonderful session. Thank you so very much for sharing all the examples. I think the practical tips that you've given make an absolute lot more sense than basically just going ahead and preparing responses, focus on hearings that we have to do, examiner interviews that we have to do, and the do's and the don'ts that you've mentioned is very critical. Distributed infringement, avoiding all of those practices that you've mentioned. I think they're all very, very important. The questions are can be asked verbally through the audio, or can be put in the chat box, and I'll keep asking them up. I already have one question, Miku, for you, where you probably can also read that in the chat box, which sort of is from Gargi. It's been sent only to me. How can we ensure enforceability or avoid design around of AI patents while drafting claims, Miku, is the question.
How do you handle, so the question is how to handle the detectability issues?
How do you handle enforceability? Basically, how do you ensure that
right.
design around will be difficult for a potential infringer?
So, so the exercises that I always go through with a client when I'm drafting these applications and claims is that probably you need to consider look at it from the viewpoint of a patent lasts for 20 years. So if you file a patent application, what is going to be your what is going to be the improvement on your patent application? Because the worst thing is to file a patent application and then have 10 people fence the improvements around your pioneering technology. So you push a little bit in the invention intake with the inventors and the client to flesh that out, and that avoids the issue of enforceability, number one. Number two, it's true that we have rules in the USPTO and in the courts for how to do discovery. So understanding the discovery system, understanding what it takes to infringe. How do you detect when AI is being used? Think about it from the perspective of trying to gather discovery and prove that someone has infringed. And when you first write the claim, we think about our experiences in litigation, right? That we've been in where we've had these difficult points of proving infringement, and we use our knowledge to try to figure out at the beginning and write a claim that's easy for the public to understand, but also, and the judges, but also easy to go in. Think about it from the perspective of going to a server or going to process some signals and trying to determine if there is infringement. If you're having trouble to do that because of the claim, it's going to be hard to enforce. And it's just an iterative process of thinking about the language, right?
Miku, there was a question on art units. If you believe that the USPTO is sort of incorrectly categorized in the 3600 art unit, is there a way that you can make a request to the PTO to put it across and justify it with your claims in the specification that it should have been, for example, in the 2600 art unit?
That's very difficult. Once you're in an art unit, your case is assigned to an examiner. And the concept of being able to advocate for switching examiners and switching art units is frowned upon, because USPTO does have some methodology. They have an algorithm for putting you in an art unit, so there is a justification for being there. Once you're there, there are a couple of things that you can do, even if you can't get that application out of the art unit. If you feel like the drafting of your application did not use the correct terminology, and you can draft a continuation that has more precise terminology without adding new matter, you can try to file a continuation or a CIP that has the additional technology there, and see if that ends up being classified in another unit. I will also say that there are a lot of good tools out there that I think allow you to put a specification through the tool, and the third-party tools that will help you predict what art unit to go to. Some of these automated specification evaluation tools, and we use one, and it will run through there. It'll look for claim issues. It'll actually look through the drawings, and then it will give you a prediction of the top 3 or 4 art units based on its own algorithm, looking at recently issued patents and recently published applications. So I would use those tools, and it's very hard once you're in an art unit. It's really frowned upon to try to change examiners or art units once you're already there.
Oh,
and I haven't seen it done in 20 years.
Fair enough. There's a question from Gargi again asking about neural networks. If a neural network is used in a stock forecasting application, does this application area fall under 35 USC 101? Is there an applicable, is such an application patentable in the US, is what she's asking.
So this is a financial services patent, and historically financial services patents have a very high rejection rate. consider software as a series of commands, a series of instructions that put data through in a particular sequence and process it in a certain manner. If what you're doing is simply applying AI, and I put a tip in here under the don'ts, right? Avoid claiming use of existing AI for a different type of data. If you're simply taking AI and you're applying it to stock market predictions, the same way you apply something to predicting the weather or predicting a heart attack, you're simply using existing AI for different types of data. You have to show exactly in the signals and in the commands what's so special about the stock market that is different from general data that it makes it worthy of an invention. You have to go further. I would say that having a different practical output with the same core technology is going to be a little bit of an uphill battle. So look, at that point, I always push the inventors. There must be something else that you're doing on the back end. Why can't somebody that, the public just take one of these stock algorithms and what you're doing to get investment for capital in your business? You must be doing something more. Let's talk about it, because it's important to push the inventors at this point, I feel. I think that's my answer. You do need more to have a better chance. It's not a 0%, but I think it's very hard in that situation. And hopefully that was a helpful answer.
Absolutely. In fact, a lot of time, inventors, in the applications that we also drop, don't really have much meat into the technical aspects of it. They're talking about use of AI in certain application areas, and their whole life cycle, or the whole scenario, the whole thing that they want to get a patent on is more functional in nature. So it's pure functionality, which talks about certain input of data, and then they do talk about AI 10 times, while talking about the algorithm, but it's purely functional. So it doesn't really talk about what algorithm, how are they training it, how are they using it, how is the AI helping at a technical level. And with such applications, you'll always have a challenge, because what you really have is, a functional patent which is not supported by the how the AI is actually being used or is contributing to the working of the function.
That's right. And, the more that you mentioned about having lots of functions, the more under US law, it's possible, and it happens a lot, where your claims are categorized as means plus function, which means you're limited to the corresponding structure in the specification. When you talk about software, structure is algorithms. So when you write patents that have functions but not algorithms, it's very difficult to get enforceable patents on that, because you may not have supporting structures to have a proper claim construction. You may end up with 112 issues. So it's important to have a deep specification with what are you doing, why are you doing it, how are you doing it, and how could it be done differently for all of your use of the AI and software. Yeah, that's a good point, Tarun.
So any other questions that colleagues have here, feel free to ask. We have a few more minutes that we can take out of Miku's time here.
Yeah, and hopefully feel free to have a comment or question. But the question of whether an AI can be an inventor, that question will continue to trickle its way and try to make its way through the courts. And I suspect we haven't seen the last attempt to have an AI be an inventor. I would say that it's at this point very unlikely, because in the US, in the EPO, I think it stated, and UK IPO has come out and stated this explicitly, that an inventor is a natural person. I think that's in the statute. And in the US, that's been some similar statements, because an invention is also part of it is conception and part of it is reduction to practice. AI can certainly do reduction to practice. And the question is, and it's a philosophical question that won't have an answer today, but what level of intent is required for conception? The courts will often depose inventors. Inventors will have to declare certain things to be true and sign a declaration. That is required by the law. And in order to declare certain things to be true and sign them, you have to form intent to sign a declaration. So these are things that will go a long way for the future. But I think all of these issues, the USPTO and all the patent office are going to iterate on and think about. So yeah, these will continue to come up, and all of the other issues. What the USPTO had questions on is actually a very long document. It goes into copyrights, it goes into trademarks, it goes into all, data privacy, all different areas. Actually, it's a very comprehensive RFQ. So I'm hopeful that out of all of that, we'll get some more clarity. And keep in mind, it is, AI has been around for a long time. AI is not something that is just appeared on the stage for the first time. It's just that it's become accessible to industry because of the supporting platforms and infrastructure that we've innovated and deeply integrated with each other. The cloud and the GPU or NPU and the 5G are all connected to each other in a way that allows us to really harness this.
Absolutely, Miku. I think we are all done here. Thank you so very much for all your time and for sparing an early morning of yours. And thank you very much. I'll get the sessions being recorded and will be uploaded on YouTube in a few days. And Miku, do you mind sharing your contact details, your email address, perhaps if colleagues here have questions that are specific to their applications?
Sure. So I should have included that in the last one there, but it's just my first name and my last name at procopio.com. You see Procopio, you see my name Miku Mehta, and at procopio.com. Please feel free to reach out if you should have questions, either through IIPRD or directly to me. And I'll be happy to answer, and I hope one day in the future we can have one of these in person in India, and I'll meet each other next year. So Miku.Mehta at procopio.com. So yeah, and you can find me on LinkedIn or anywhere else website if you need.
Absolutely. Thank you.
Thank you again, Tarun, for inviting me to
pleasure. And I look forward to stay in touch, Miku. Thank you very much again for the session. Thank you everybody for joining in, and we look forward to getting back again with another session in a few weeks. Thank you again. Thanks, Miku.
Thank you. Have a nice weekend. Bye-bye.